honorable members, guests, ladies and gentlemen, अस्सलाम वालेकुम। पहले तो मैं सब आपका मशकूर हूँ कि रोज़े के वक्त जो ये इस वक्त टाइम होता है वो रेस्ट का होता है, लेकिन आप सब की मौजूदगी इस बात की गमाज़ है कि आपकी कमिटमेंट है इस कॉज के साथ। So I must personally thank you for listening to me and to other speakers. Ladies and gentlemen, I think there is no doubt about the very clear thesis that international law is being violated in Indian occupied Kashmir. So it's taken. It is also clear that we don't even need to argue the specific instances of those violations. The question is, what should we be doing in respect of those violations which are happening around us? Mrs. Malik is here. The people and the heroes in Kashmir are facing the brunt of brutalities that the Indian occupied force is doing there. How do we go about putting our case and the case of those Kashmiris before international forums, including United Nations? That to me is the question that has been put to me. And my submission would be that first of all, we need to document specific atrocities. A broad brush and a broad narrative that there has been violations is something that international community is somewhat fatigued to hear over and over again when we go to international forums. But when we document it like we prepare a case, then optics begin to change specifically. One of my senior counsels is sitting, he knows what I'm saying when we say we have to prepare each case separately, file of each atrocity separately, file of each individual who has been inflicted with human rights violation separately, name, details, instance, date, occurrence, nature of injury, inflicted by who, potentially identified which military unit was deployed in that particular area, what exactly is the nature of injury inflicted, and so on and so forth. And we need to prepare our list of those individuals who could be sanctioned or that we could claim needs to be sanctioned of the Indian Army. Just like the Leahy Amendment, if you recall, some people may recall, the Leahy Amendment in US creates a direct sanction in respect of individual military officers anywhere who are violating human rights. Their travel, their other encumbrances on their right to enjoy life is being imposed. So why can't AJK government of Pakistan, come out with a potential database or an office of human rights violations in Indian occupied Kashmir, document this, link it with specific units of Indian Army, and say, Mr. Such and such is alleged to have committed this offense under whose command this military deployment was operating in this particular sector, in this particular city, in this particular town. That is when you start documenting the violations. And then you identify from Indian cases, from Indian Penal Code, which provision has been violated in each specific instance. And then you build an argument that here is a case, stack of files. Whether pellet guns, broadly, yes, we have pictures, we show them, we talk about them, but have we listed down those names? As I say, we should. Just like we prepare each individual case to be presented not only to our own people, so that they understand the gravity of what's happening, but also before the international community. So an Office of Human Rights, it could be parked in the Human Rights Ministry of Pakistan. And why it should be of concern of Pakistan? Because it bears heavily on the conscience of citizens of Pakistan. They need to know what is happening to their brothers in Kashmir who are facing this brunt. So once you prepare through this proposed Office of Human Rights Violation in Indian occupied Kashmir, this office, as I said, could be parked anywhere, then you can reach out to international community with reference to violations as these each case is documenting, and measure them against international conventions and treaties, and identify those violations with reference to those provisions, because it is not merely a violation per se of human rights as has been given to me in my topic. It is a violation of international humanitarian law. It's a violation of law of war. What's happening in Indian occupied Kashmir is not merely a human rights situation, it's a situation of occupation which is clearly established pursuant to 4th Geneva Convention. We need to use the lens of law of war to examine human rights or humanitarian law violations. And when you use that particular lens, these instances that I am highlighting, what is happening and what have been indicated, convert into war crimes in terms of Article 6, 7 and 8 of International Criminal Court. So you identify each file that which particular crime is being committed, which particular provision is being violated, not only of the ICC, but also of all the 4 Geneva Conventions. Because as I said, an occupying power has restricted mandate. It cannot bring changes, it cannot commit human rights violation. It cannot change the demography. And if you look at Article 35A of the Indian Constitution, it is a miniature version of the 4th Geneva Convention. The kind of restrictions it puts with respect to the territory of IUK are the kind of restrictions that are elaborated in 4th Geneva Convention. So it is a classical case of an occupying army. And when an army occupies a territory, the people of that territory have a right to resist that army. That is so clear in international law. People who are under the occupying force have a right under international law to resist that occupation and even use force if the case may be so warranted. So Article 35A, which is in the Indian Constitution, is a big neon sign trying to convince us in Pakistan it's an occupying army paradigm. It's an international law of war paradigm. It's an armed conflict paradigm. It's a paradigm that needs to be used in that context. We kind of continue to restrict the paradigm only to human rights, which is a very restricted paradigm. In human rights, you're talking of simple offenses, but the same act of having somebody put on the bumper and being paraded, or use of pellet guns, or rape, or any that which is normally a simpliciter offense in the human rights paradigm becomes a war crime when you put armed conflict lens around it. And 35A is a legal indicator that this is an armed conflict paradigm, and therefore the right to resistance is inherent, and further, the right to extend support to those who resist is also on the third states, including Pakistan. Not only Pakistan, but all these states have a duty under international law to extend support to those who are clamoring for the right of self-determination. There are only 2 venues where right of self-determination is viewed as a right genuinely anchored in that territory: Palestine and Kashmir. Any other group of people asking for separation or independence is viewed as violation of succession. It is successive movement. It's movement of successive, which is trying to separate from a state, which becomes an offense. But in these 2 areas, Palestine and Kashmir, it is globally recognized. It's a right of self-determination, which means all states of the world have a duty to extend support to them. So it's not merely Pakistan's responsibility. Pakistan is one of the states, and this is something, the duty that we need to invite, the duty that we need to indicate. Article 370 of the Indian Constitution also is a huge neon sign in the Constitution of India, which contradicts the political position of the Indian government and the incoming new Prime Minister Modi again. What BJP has been saying, it is atu-tung, it is part of Indian territory. What Constitution of India has been saying, no, it's a separate territory. So Article 370 is demonstrating that the constitutional position of the Indian Constitution is in contradiction with the political position of its government. And clearly the Constitution needs to prevail. So therefore, Article 370 needs to stay where it is. And that is why it hurts BJP. It hurts them badly because the entire narrative of Atut Ang is destroyed because 370 obstructs that. So what are they trying to do with 370? They are trying to have it shoot down through a legal process, launch a lawfare in respect of Article 370. They tried in 2015 before Jammu and Kashmir High Courts twice. The Hindu judges gave a verdict, no, it cannot be touched. Article 370 needs to stay because it is guaranteeing limited sovereignty of IUK. These are the terms used in that judgment. Article 370 means the Riyasat of Jammu and Kashmir retains limited sovereignty. That's so written by the judges of the Jammu and Kashmir High Court. So they were upheld. Another lawfare move was tried. And the lawfare move was that there is a separate enactment about the flag of Kashmir which has to be hoisted as a state flag along with the flag of India. Separate statute for that. So an effort was made to argue that this statute needs to be declared ultra vires in the Indian Constitution and only flag of India should be hoisted. That judgment also was turned down. They have filed an appeals. They are all lawfare moves which are actually in favor of Pakistan, but nobody in Pakistan is picking it up. It's not occurring on the radar of our country and other countries that all these significant legal developments are destroying India's case, which they are trying to sideline. So then what is now being attempted, having failed in Jammu and Kashmir High Courts at the hands of the judges who are of Hindu origin, attempt is being made to take Article 370 directly and challenge to the Supreme Court of India. So there a petition has been filed in the Supreme Court of India challenging Article 370. 1.5 years back, Indian Supreme Court had turned down such a challenge. Now, surprisingly, there's a very interesting coincidence, ladies and gentlemen. The case was fixed for 26, 27, 28. In Supreme Court of India, it was announced. Airstrikes, these are exactly the dates of the airstrikes on Pakistan. I am a lawyer, so I am not in a position to draw conspiracy conclusions out of it, but you can think more on that. Why? And then that list was cancelled. One of my researcher team was following the developments at what happened to the list which is normally issued a week in advance by the Indian Supreme Court in respect of these Article 370 challenge. The cases were cancelled, taken off. When will they be heard? We don't know. What will happen? We don't know. Is there a lawfare framework being applied by the Supreme Court of India or not? Should some Kashmiri become a party in those proceedings and argue, don't do this? You do not have a locus standi to do this. You should not do this. Should Pakistan not take up this matter at international forums, that touching Article 360 and giving Attorney General of India instructions to oppose it is a very serious development at an international level. So we need to pick up these indicators to build up the case that Kashmiris are being sidelined. An effort is being made to silence them. An effort is being made to completely make them redundant in terms of their individual rights. And what more, we now see another trend of vigilantes that you have been mentioned, cow slaughters, people and Muslims. What is this all? If we put it in international law jargon, it's a racial discrimination of the highest nature ever occurring in the recent times. It is discrimination on the grounds of religion, a gross violation of International Covenant on Civil and Political Rights, ICCPR. We haven't formulated this so far. We need to formulate this. We need to read what's going on. Discrimination on the grounds of religion, not only perpetuated by ordinary Hindu Indians, whether they belong to RSS or whoever, but even been practiced and advocated at a state level by representatives of the state, including one of the chief ministers. Gross violation, admitted. You don't even have to prove it now. Sometimes you need to have an incidence, and as lawyers we are trained to make an effort to prove the incidence. But if it is owned by the state representatives, it is admitted. Now all you need to do is to present it to international community. In the right legal phraseology, presentation of a case is an art. When you go to a normal court of law, you know your case better than anybody else. Whether it's a case of a tenant, whether it's a case of dispossession, you know it, you know the registry, you know the land, you know the receipt, you have been receiving the rents and everything. You know it better than anybody else. You've executed your documents, you bought this piece of house, you rented it out, you executed rent deed. Then why do you go to a lawyer? Why do you get a lawyer? Because his ability to articulate your facts is far superior to yours. His ability to see through your weakness and strength is far superior to yours. You are hostage to your own facts because you have traveled through them. That is the combination we require. If you want to have improvement in leveraging the case of Kashmir relating to human rights with the global community, we need to raise a team of lawyers, young lawyers. We need to invest in lawyers in overseas, people who could see this case in a very different context. It is shocking that so much is happening in Kashmir, but not even a single legal journal of credibility has given space to human rights appraisal from a legal point of view. No conference of international legal community has been convened on this. No association, International Bar Association, has talked about it. So, ladies and gentlemen, I believe that if we need to present the case of Kashmiris to international community, whether it is United Nations or others, all these, wherever you go, whether you go to a certain country, whether you meet the politician or representatives of that particular country, or you go to an international organization trying to present the case, do you know what do they do with that document that you give to them? They refer it to their legal division for comments, for appraisal, for review, and ask the legal division to come back and tell us what is the weight in this. So whether it is the State Department's legal division, it's the UK's Department legal division, it's the EU's Department legal division, the document that you hand over, your Prime Minister hands over, or your official hands over, is passed on to the legal division for appraisal. Ask yourself, does it contain the material that it should contain, in which the legal division of any entity should say, there's a very solid case here, we need to stand by it. We tend to lean on rhetorics, we tend to lean on emotions, we tend to lean on applying to the compassion. We have been doing it for so long. See the comparison. When an international lawyer like Sir Zafarullah Khan was handling this case, Quaid-e-Azam had handpicked him and asked him to go and represent Pakistan in UN. During his tenure, these 14, 15 resolutions came out. He took the legal course. He took the legal arguments. After that, no resolution. We have been taking an emotional route. So my suggestion is that let's try legal diplomacy on Kashmir. Let's look at the legal dimension of Kashmir, which is so strong, so strong. Ladies and gentlemen, again I quote my senior lawyer who is sitting here, that we turn on head a very weak case which is brought to us by any litigant. Kashmir is such a strong case, we feel like crying that we have not been able to sell it. It's such a strong case. There's so much into it, every aspect of it. Its history, its present, its human rights violations, a small component of that. Every bit of it is so solid in favor of Pakistan. And if you revert to legal diplomacy, I'm sure you'll be able to regain the attention. And one last point. What was the watershed event after which we began to lose perception on Kashmir? It was Mumbai. Mumbai event and post-Mumbai treatment, the way Indians piled pressure on us, and the way we failed to explain to international community that we are doing what we can to handle the Bombay trial as good as we can. But it was assumed that we are protecting terrorists. India was able to sell this. We were not able to sell to the international community for several years. For almost 10 years that case has been pending. We haven't been able to explain how much we have invested, how we have made efforts not to allow bails. And that perception that these people or contingents of this are present inside Kashmir and therefore it is a counter-terrorism framework, that has not helped us at all. So I believe while we look at legal diplomacy, improving perception and clarifying doubts with relation to the Bombay trial and the efforts of government of Pakistan, successive governments of Pakistan, distancing themselves from Mumbai actors, from all irresponsible actors, and saying very clearly over and over again, including the present Prime Minister, that we will not own any irresponsible acts of even our citizens if they are occurring outside our territories, is very important. That perception, led with the lawfare approach that I am suggesting, will bring back Kashmir to the center stage where it truly belongs, and that is how we will be able to justify the sacrifices of heroes of Kashmir that they are doing in Kashmir. Thank you very much.